Thank you, everyone. We want to welcome you to the Thursday meeting of the House Judiciary Committee. And I'm supposed to be recognizing our Judge, Mike Boggs. Is he in the audience anywhere? He going back home. All right. Well, he's got about a 4-hour drive anyway, so we better get started. That's fine. Well, here we are, Groundhog Day. House Bill 24. like the movie. It's all over again. We do have a rehearing on House Bill 24, which is the evidence code, and that is for reason of a one-word error that we found since the time it came out of committee and went up to rules. And I'm going to let, first of all, if I might invite our legal assistant, from Legislative Council, Ms. Travis.
Yes, sir.
Front and center, would you point out to the committee the change that was necessary to be made?
Actually, two. One was on page 16 at line 501. The words that were missing in the version you all saw last were of subsection A.
Yeah.
So before it just read in paragraph 1 of code section 24-5-501, but they should have said of subsection A. It could have been corrected on a CC note, but since we were reprinting the pages, I went ahead and made that.
All right. That's the first one. And second?
The other correction is on page 39 at line 1285. The word may, halfway down the line, is there. Previously it said shall. In current law it says may.
I lost the line number.
1285.
1285, thank you.
How it got to shall, I don't know, but it was a mistake. It was a mistake that's been there since the first time this bill came through.
All right. And in fact, what you're saying is that the actual existing current statute,
Right, 24-3-18 says may.
right, which is now being recodified as 24-8-826,
Correct.
had the word may, and somewhere along the drafting process, that may was inadvertently made into a shall.
Right.
Now, I know Mr. Clark wants to explain, as he was one of the people that brought this to our, or was the person who brought this to our attention. There's Bill. Come up, Mr. Clark. Let me have you explain why your organization feels this may have presented a concern.
Thank you, Mr. Chairman, members of the committee. Bill Clark on behalf of the Georgia Trial Lawyers Association. This was inadvertent. It was never discussed in any of the study committee hearings or any committee hearing that's been held. This is what's called the medical narrative statute. Either party can use essentially a medical report by a doctor or some other healthcare provider to lay out the facts of his or her treatment, examination of a patient. It's a cost-effective measure that was enacted maybe a decade or more ago to help, frankly, particularly in smaller cases, get parties to get the case handled without the additional costs of depositions and that sort of thing. One of the provisions in here, the one where the error appears, says under current law that a statement of the qualifications of the person signing the report may be included in the report. The bill inadvertently changed that to shall. Well, why is that a problem? It's a problem because if qualifications shall be included, every single one of these reports is then going to be subject to a challenge for insufficient inclusion of qualifications. The qualifications of the person can be challenged if the other party wants to through depositions. Currently, they'll still be able to do that. We just thought that this would beg the fight in every single case about the qualifications, the quality and quantity of qualifications of the person preparing the report. And that was never the intent of anybody working on this on either side. because frankly both sides can use it, and to continue with the cost-efficient premise of this whole statute, we feel like the word may ought to remain as it is in current law.
As it has been, correct. Anyone have questions of Mr. Clark? Yes.
What's the existing code section?
24-3-18.
And
That's from memory, so.
she and I have the same accurate or failing memory on that. I think it's 24-3-18.
You want to look at it? All right.
The only substantive change in that entire code section in this bill is this may to shall, and we're asking it go back to may. There were a couple of musts that were changed to shalls for stylistic purposes.
Right.
And my speculation is that during the literal typing out of the words, somebody changed not only a must to shall, but the immediately following may to shall,
Okay.
and that's how it inadvertently happened.
All right.
Thank you, Mr. Chairman.
Thank
members of
you.
the committee.
And while Mr. Lindsay takes a review of that, is there anyone else wish to address the committee on House Bill 24? Thank you. We'll close off the further public input. Do we have a motion?
So moved, Mr. Chairman.
Second.
It moved, and it has been second to do pass
Yes, do
as
pass
a committee,
294572S.
Second.
we have to we do it as a
Committee stuff.
committee substitute, because we have amendments to it at this point in time, I believe. But first of all, we'll have to see the amendments. The first one suggested was page 16, line 501, inserting the phrase of subsection A after paragraph 1. Correct?
Well, you can just pass the sub.
Yeah, the sub has it.
Oh,
in
they're
here.
already in there? Okay.
The sub has it in here, Mr. Chairman.
Well, I'm looking, go back, excuse me, I'm sorry. Look on line 24-826. Mine has here shall be admissible and received in evidence.
Mine has may, Mr. Chairman.
Line 1285.
1285, excuse me. Okay, may be included, yeah. And so the first shall remains a shall.
Correct.
Okay, excuse me, I made a mistake there, yeah. And so at 1285, we do have the word may included after report. All right, so we've got a do pass as a committee substitute, 294572S. Any further discussion on the motion? Any further amendments? There being none, the main question is called. All in favor of House Bill 24 as amended and as a committee substitute, not as amended, excuse me, as a committee substitute, please signify by saying aye.
Aye.
Opposed, like sign. One no. All right. Thank you. We do have a do pass of House Bill 24, committee substitute. Next we have on the agenda is Mr. Jacobs' House Bill 64, and I will recognize Mr. Jacobs for the purpose of explaining House Bill 24 and its history.
Thank you, Mr. Chairman. I bring before the committee House Bill 64 via committee substitute. This is how it passed out of subcommittee LC 294546S. This is an amendment to OCGA 13111, which is the attorney's fees statute for contract cases, or one of the two attorney's fees statutes for contract cases. The issue came up in discussions with Vice Chairman Matt Ramsey prior to the legislative session. Both of us have had law partners who have encountered a situation where when you have a contract or promissory note that has a high principal value, the percentages for attorney's fees set forth in 13111 can result in some obscenely high results. in terms of the attorney's fees awarded. So say, for example, the percentages are 15% of the first $500 and 10% of any amount above and beyond that. Let's just use 10% to make it easy. Say you have a promissory note with a principal value of $2 million. That would result in assuming that the provision in the promissory note provides for reasonable attorney's fees and does not otherwise spell out how the attorney's fees are to be calculated, that would result in $200,000 in attorney's fees. For a case that ultimately you have the party to be bound's signature on the promissory note, might be a fairly simple case that doesn't cost but 10% of that to bring, but you could end up with $200,000 in attorney's fees for what might be a $20,000, $30,000 case, if that. So the question is how we address, now of course there's a policy issue with regard to lower principal value notes and contracts, and that is really what 13111 is aimed at, is allowing those cases to move efficiently and capping the attorney's fees in those scenarios. But unfortunately, it doesn't really provide a cap at all once the principal value becomes larger. And you've got a case also in your file, and this is like I said, I mean, a law partner of mine has encountered this situation. A law partner of Vice Chairman Ramsey has encountered this situation, and here you have a real-world case. Pacific Mutual Life Insurance Company versus Wise. It's an 11th Circuit case, 878 F. 2nd 1398, where if you turn to the reverse side, I've just copied the relevant portion of the case. You can see that the 11th Circuit is saying that applying 13111, that we have to apply 13111 as it's written. And so the attorney's fees award here of $637,000. $637,058.22 is what the statute demands. So that's what we have to award based upon what 13111 says. Now the bill, as it came to subcommittee, simply struck through the percentages and said that it would be a reasonable amount, an amount found by the court to be reasonable under the circumstances. We heard some testimony and then determined that we don't really want to be affecting the low dollar value, the low principal amount cases, but rather we're really getting at the high principal amount cases. And so the operative language of the bill is now there on page 2, starting on line 36, where we say that if the dollar amount of attorney's fees that would result from applying the percentages exceeds $10,000, the party that would be charged with paying the attorney's fees can move the court for a determination of reasonableness of the attorney's fees. The court then would take an affidavit from the party that is seeking attorney's fees. They could either determine it based upon the affidavit or hold an evidentiary hearing. But at the end of the day, if the principal amount is higher than $10,000 and the party that is charged with paying the attorney's fees files a motion in court, the amount awarded shall be an amount found by the court to be reasonable and necessary for asserting the rights of the party requesting the fees. So that is, in essence, what House Bill, the sub to House Bill 64 does. I should also say that the State Bar has taken a position in support of the bill, and I'll be happy to answer any questions about it.
We have questions. Mr. Hatfield.
Thank you, Mr. Chairman. I like the bill and the your explanation of the reasoning behind it. I just had a question on subsection C, lines 47 and 48. What was the thinking behind that?
The answer to that is that 13111 applies not just to contract lawsuits, but also to the non-judicial foreclosure setting. You can see that what is being moved from subsection B to become subsection D does that. What we didn't want to do was enable an invocation of this subsection in a case that isn't already in court, where there is no case. All right, so there has to be an already pending contract dispute in order to invoke this subsection. So you can't just file an action to invoke this subsection in the first place.
And couldn't use that as the basis for a declaratory judgment action.
Correct.
Okay. All right. Thank you.
Yes, sir. Mr. Lindsay?
Thank you, Mr. Chairman, and I also agree. I like the bill. The one question I have, as I look at the bill, and is there an opportunity by the party opposing the amount of the fees to engage in limited discovery regarding the reasonableness of the attorney's fees? You can do that in federal court. If you object to the attorney's fees that are proffered in federal court, you're allowed to depose and also do limited discovery on the fees.
Well, there's no specific right granted here, but there is an opportunity to respond to the affidavit that would set forth the attorney's fees, and then the court is entitled to hold an evidentiary hearing. I mean, that's what the provisions of the bill provide for. So there would not necessarily be evidence taken in every case, but there is the opportunity for evidence to be taken on both sides.
I guess my question is whether we should have one of two things: either require the court to hold a hearing in which the person asking the fees can be cross-examined, or require or allow for discovery prior to the court's ruling.
Well, I would think that the opportunity for discovery would be within. I mean, it certainly the court has the ability, if it sees that, and I would be fine. I think it's fine to leave this in the discretion of the court. I think the court already has the ability to allow for limited discovery on that issue if they want to. I mean, that's to begin with within the inherent power of the court, and then we also make it clear that the opportunity to hold an evidentiary hearing is there too. I think that the courts would be able to address that situation on their own without us needing to spell it out in the bill. I think you could have discovery in this scenario without us having to say it.
All right. Thank you.
Yes, sir.
Mr. Chairman, just as a follow-up to that, why would discovery not be appropriate just in the action generally with regard to those issues of attorney's fees?
I think it is. I mean, I think you could as long as there is a claim pending for attorney's fees, then I think the issue of attorney's fees is pending for discovery in the action.
Right. That's what I would think.
Yeah.
Further questions, members? I have a couple of them. You mentioned the State Bar has expressed support. How is that support being expressed from the bar?
Well, it was communicated to me by Mr. Bowler today, as a matter of fact.
But not Board of Governors action or what? Committee meeting?
I think it was the executive committee.
The process the bar has.
Oh, there you are.
In session, while the session is is that the
Process.
executive committee considers bills and
Okay.
resolutions when the board of governors cannot.
Okay, thank you. The other question I have is, are we doing anything to affect existing contracts where we're saying we're changing
The answer is no. Of course, 13111 is a substantive provision of any contract that is signed at the time the contract is signed. So the effective date, if you look at the effective date provision in Section 2, this act shall become effective on July 1 and shall apply to contracts entered on or after July 1. So no, if you have a contract that is currently in place, the existing 13111 applies to it.
So if I have a contract that expresses in there that I'm entitled to 10% attorney's fees upon default and collection, that 10% will not hold as to the provision of the contract, but saying the statutory provision as to reasonableness will now apply?
No, that 10% provision applies in any event. The percentages only come into play when you have find the specific language, but when you have a provision in the contract that says that providing for reasonable attorney's fees, That's where you get to the percentages in 13.111.
Okay. Okay. Thank you.
So you can always contract around 13.111.
Yeah. Further questions of anyone? I don't know. We didn't call for anyone in the audience. I apologize. Is there anyone who would like to address the committee on House Bill 64? If not, we'll close off further public input. The bill is now in the rest of the committee. Do we have any further discussion? If not, do we have a motion? Move, do pass, and second it. Discussion on the motion. No discussion. Do we have any amendments? There being no amendments, the chair calls for the main question. The question is do pass House Bill 64 as a committee substitute. All in favor signify by saying aye. Aye. Opposed, like sign. Register one no vote. The motion by chair's declaration passes. The next bill we have will be Mr. Taylor. Mr. Tom Taylor, please come up, and we're glad to have you with us. First appearance. Welcome to us.
Thank you, sir.
You're here on House Bill 793, excuse me.
Sir, thank you, Mr. Chairman, members of the committee. I bring House Bill 93. This is a committee sub, the way it passed out of subcommittee. Working off of LC 294574S. And what this bill does is basically changes a definition in code. The of code inspector, which is sort of an archaic term that's still on the books, to code enforcement officer, just the definition. The rationale for this is the older term with code inspector has kind of been superseded by code enforcement officer, and the purpose of this basically is the national and state accrediting agencies and professional associations use this as an industry term now. What the purpose of this is to change the Georgia code to match up with that, so the folks from municipalities and counties here can apply for, the language is correct, they can apply for federal grants and scholarships in order to get training. Entertain any questions?
Questions? I was just looking at it. I have a question, I think, Mr. Taylor. I was just looking at it, and I'm reading at line 12, where we give the definition of code enforcement officer means any person employed by a county or municipality, etc. I think your city of Dunwoody, and I know the city of Sandy Springs, has code enforcement officers who are actually contracted with, as opposed to in the employment of. And I wonder if that might, in some way, perhaps be disqualifying if they're not actually an employee of the city or county. Would you be open to having that modified?
If you suggest it, sir, certainly I'd like to tighten that up to make sure that we do not have any disputes arising out of that. I know we both have contracts now. I think by extension you could say yes, they're an employee of the city, but I would like to tighten that up if you think it's
I mean, I see when you start talking about criminal prosecution, definitive terms is what person has a right to take action against someone needs to be very clear, and I wonder if that may be a problem. We just don't make a change there. And I see we got a question from Mr. Lindsay.
Just a possible suggestion, Mr. Chairman, to the author and to the chairman. After employed on line 13, could we fix this by simply adding the term or contracted?
That's what I've done already. There we go. I did after person as opposed to employee. Person contracted with or employed by a county. Either way probably works out. Any further questions of the presenter? Do we have anyone else who would like to speak to the committee on House Bill 93? If not, we will close off further public input, and it's now in the rest of the committee. Any discussion among committee members? No further.
At the appropriate time.
Yes.
Actually, on that amendment, I did want to ask Ms. Travis which stylistically she liked better.
I like the chairman first.
Let Ms. Travis speak independently.
Chairman sounded great.
Oh, shucks. Okay. Any further discussion among the committee? If not, Chair will entertain a motion.
Move to pass, Mr. Chairman.
We have a motion to pass. Do we have any amendments?
Yes, Mr. Chairman.
And your amendment, you'd like to present your amendment?
After person, add the words contracted with on line 13.
Or?
Contracted
Right.
with or.
Gotcha. Does everyone understand the proposed amendment? Is there a discussion on the amendment? Chair will ask vote on the amendment first. All those in favor of the amendment, the Lindsay amendment, signify by saying aye.
Aye.
Opposed, like sign. Amendment carries. Any further amendments to House Bill 93? If not, the chair will call for the main question. All in favor of approval of House Bill 93 as amended as a committee substitute, signify by saying aye.
Aye.
Opposed, like sign. We have a due pass on it. Thank you, Ms. Taylor. We have one last bill, Mr. McKillop's House Bill 129. Is Mr. McKillop here today?
Yes, sir, there.
I'm sorry, I couldn't see you right there. I didn't. Pardon me. You've been quiet.
He did all his talking.
That's fair. Thank you, Mr. Chairman.
He's worn out.
Let's see. I bring before you today House Bill 129. This has been through subcommittee, and we've worked with a number of learned attorneys to try and perfect this language. And I'll briefly describe for the full committee the point of this bill. There have been some situations in Georgia where some developers have begun instituting a fee on transfer of any property that they have developed. So they might go in and do a 1,000-unit subdivision and encumber each of those lots with a 1% fee on any transfer or sale of those lots. Fannie Mae and Freddie Mac are right now in the process of updating and modifying their rules to forbid mortgages being purchased on properties with those kinds of restrictions. And I think over 20 states nationwide have already in some way outlawed these fees. That is, that it's just an unnecessary encumbrance of real property and a hindrance to the free and easy transfer of real estate. What you have before you is LC 294590 ERS. We did have a late amendment in the subcommittee that we took to Ms. Travis, and as is often the case, we have a Travis amendment to that language, which tightened it up significantly, and that's the change that can be found is in lines 33 and 34. What we've done here is in the first section we've prohibited the fee on transfer by a declarant or person imposing the original restrictive covenants, and then carved out an exception for legitimate homeowners associations and condominium owners associations, both those acting pursuant to those specific acts, and homeowners associations which are not acting pursuant to the Homeowners Association Act, or rather the Georgia Property Owners Association Act, but which do comply with certain notice provisions in that act. And so we've created the prohibition and then drafted in the exception, and the exception language is what we've been working on. We think we have it now to a point where it's tight. The stakeholders in this that have appeared and worked hard on this bill to get it to the point that it's at, the State Bar, the Real Property Group, the Community Association Institute of Georgia through Julie McGee Howard and Randy Lipschutz, the Georgia Land Title Association through Diane Calloway, and Ron Fennell, a former House member, who's a representative for both those groups. So I'm happy to answer any questions about it.
All right. Thank you, Mr. McKillop. Anyone have questions of Mr. McKillop, first of all, on the committee? Did you, Mr. Lindsay? Okay. Excuse me. If not, we do have those in the audience who would like to speak on this bill. We have Ms. Julie Howard. Ms. Howard, would you come up and have a seat?
Thank you, Mr. Chairman. I won't take your time, but I'm here to answer any questions and to express my support for this bill. I practice community association law. I'm a partner at Weissman Nowak Curry & Wilco, and in my free time, I am the chair of the Legislative Action Committee for the Community Associations Institute of Georgia. I'm sure there's a full acronym for that. But I'm happy to address any questions. As Representative McKillop explained, our interest is in the Section C, carving out the 3 types of homeowner and condominium associations in Georgia. And we believe that the 3 carve-outs that are now provided in C 1 through 3 protect community associations' rights to have transfer fees on conveyances of property, which is a common occurrence in a lot of governing documents for community associations.
All right. Questions of Ms. Howard? Tell me, Ms. Howard, if I might, what are some of the types of transfer fees that would arise in a condominium association?
Sure. The most typical fee would be a capital contribution fee that is provided for in the governing condominium declaration that says that upon conveyance of a unit that the new owner or whoever whatever the parties worked out at the closing table would pay a fee that would go to the association above and beyond the regular assessment. And it would be a one-time fee paid at conveyance, usually for capital funds, capital reserve funds. In my homeowner association communities, we often have road maintenance fee where there's a private road. So there are fees that are collected on conveyance, again, for capital needs for the future.
If I understood correctly, this would be something that would be a capital improvement fee above and beyond what is a capital improvement assessment being made of all homeowners as a group.
Right. Typically, the governing documents provide for, in a condominium and homeowner association, annual assessments. In condominiums, they're usually levied monthly. This is, and it would only be if it's provided for in the governing documents, but it is often provided for in the governing documents, a separate fee paid only at a transfer.
Well, let me carry forward my thought. With condominiums and certain other associations, you will have a ongoing capital assessment reserve program. Right. My question would then be, is this beyond what is being done as a contribution by homeowners to their capital assessment program?
Sure. Yeah, thank you. Yes, this would be in addition to any regular contribution by the homeowners to the capital reserve budget. Most associations, if they're financially prudent, have a capital budget and they have a capital contribution out of the monthly assessment. And so this would be above and beyond that. It would be paid just on a transfer.
Why does that happen?
Why does it happen? It helps build the reserves.
Okay. Is there any limit on it? Is there any way that the documents spell out a limit, or? Typically
they do. Most of these types of provisions say something, they either give a cap, a monetary cap, or they tie it to the annual assessment. And it will be, it'll be something like a capital contribution fee is allowed on a transfer not to exceed the annual assessment or not to exceed half the annual assessment. There's nothing in the law right now that would limit the amount, but most of the governing documents do either cap it or have a percentage cap based on the annual assessment.
All right. As a further follow-up, if I'm selling my unit as a condominium and the unit sells for $200,000, and although I've had all my assessments and my monthly dues paid up to date, I could be hit again with a special transfer assessment, which dollar-wise I may not know until I'm told, okay, if you're selling, you're going to have to pay in $10,000 more to this special assessment.
Well, it's whatever the documents say. I mean, I've never seen one that's $10,000. They're usually 3 months. For a condominium, the standard provision is 3 months of the annual assessment. For a homeowners association, you typically see an amount equal to the homeowner association annual assessment, which is typically a lot lower than a condominium assessment, or some percentage, half of the annual assessment. But it's in the document, so they, presumably would know that well in advance.
Okay. Mr. Lindsay?
Actually, Mr. Chairman, that was my question. Was exactly the question you just asked.
Any other questions of Ms. Howard? Well, thank you so much for being with us today. I recognize Mr. Lipschutz, who's a long-time friend and aware he does a lot of the law. Do you want to address the committee on this point?
Actually, Mr. Chairman, Julie is chair of the committee this year, and I think she pretty much stated exactly what I was here for, what I talked about with the subcommittees when it was before the subcommittee.
Thank you, sir.
Answer any questions.
All right. So far we don't have any. That's good. Any further members of the audience like to address the committee on House Bill, what's the number? 129. If not, we'll close off further. Oh, I'm sorry. Yes, ma'am, Ms. Calloway. Pardon me. We'll let you sit there if you like. I don't know if you get a mic turned around to you. I'll be able to. Whichever one's closest for you. Yes, ma'am.
Thank you, Mr. Chairman. I've had the pleasure of addressing the subcommittee, and I'm here. I see a lot of the same faces, and I'm here to answer any questions from a title perspective. As I've mentioned previously, I've been an attorney for over 30 years, and I've owned a title company for 17 here in Atlanta. And I can only reiterate the joy that I felt learning that this bill was introduced, because there is a veritable groundswell of opposition across the country. I'm a volunteer in our national association, and we talk around the country about I hate to use a dramatic word, but the evils that this could promote. These are not unlike the condominium fees that are used to better the development. These are extraneous fees payable long down the road to third parties that have long been out of title. And I applaud you all for producing legislation to prohibit or curtail them for just purposes only.
Well, thank you, Ms. Calloway. And I think so far we might call this a preemptive strike. We haven't had in Georgia as yet that we know of the use of these type of transfer fees, and so we want to be sure we don't get into a place where people have been abused and covenants are already recorded that carry this type of thing. So I appreciate bringing this. I think the State Bar Real Property Section, in fact, has approved this as a proposed part of their legislative package, correct?
Yes, sir.
Okay.
Yes, sir.
Thank both of you. Anyone else wish to address the committee? If not, we'll close off further public input, and the House Bill 129 is now in the breast of the committee. Is there any further discussion among committee members regarding the bill? If not, the chair will entertain a motion.
Due pass by committee substitute.
We have a due pass of House Bill 129 by committee substitute LC 294590 ERS. Any further discussion on that motion? Second. Been a second? Second. Thank you. No further discussion. Do we have any amendments to propose to the bill? No amendments. We'll call for the main question, which is due pass House Bill 129 as a committee substitute. All in favor signify by saying aye. Aye. Opposed, like sign. The motion carries. We have a due pass. And I think that's all the business we have today. There's nothing other announcements, or do we have announcements? You have an announcement.
My subcommittee will meet on Monday at 3 p.m. Here in the Judiciary Committee room. We're going to take up a bill by Chairman Bearden relating to removal of magistrate judges, and also we're going to continue our hearing on House Bill 110. I know there's a lot of parties interested in that bill, so let them all know we're going to be hearing it again on Monday. Thank you.
Sorry. President's Day is, I think, Monday also, but
it's generally the General Assembly. I mean, we're open, right? Yeah. So we're gonna go ahead with the hearing on Monday. Sorry, Representative Bruce.
Love to see you. You going out of town?
I'm going to be out of town, too.
Any further? No further announcements. The chair calls the meeting to an end. We are hereby adjourned.